Ranking Member Raskin to welcome Congresswoman Tlaib.
Well, thank you, Chairman Comer, for that very warm welcome extended to our colleague, Rashida Tlaib, the favorite daughter of Michigan and a veteran of this committee, and we're so thrilled and delighted that she's back to join us. I yield back to you.
Gentleman yields back. I ask unanimous consent for Representative Jason Smith of the House Ways and Means Committee to be waived on the committee for today's hearing for the purposes of asking questions. Without objection, so ordered.
And, Mr. Chairman, I ask unanimous consent that our colleague, Congressman Glenn Ivey from Maryland, be permitted to join the committee and ask questions of the witnesses today.
Without objection, so ordered. I now recognize myself for the purpose of making an opening statement. Since assuming our Republican majority in January, the House Oversight and Accountability Committee has uncovered a mountain of evidence revealing how Joe Biden abused his public office for his family's financial gain. For years, President Biden has lied to the American people about his knowledge of and participation in his family's corrupt business schemes. At least 10 times, Joe Biden lied to the American people that he never spoke to his family about their business dealings. He lied by telling the American people that there was an absolute wall between his official government duties and his personal life. Let's be clear, there was no wall. The door was wide open to those who purchased what a business associate described as the Biden brand. Evidence reveals that then Vice President Joe Biden spoke, dined, and developed relationships with his family's foreign business targets. These business targets include foreign oligarchs who sent millions of dollars to his family. It also includes a Chinese national who wired $250,000 to his son. Joe Biden also lied to the American people about his family making money in China. He continued to lie about it even when the House Oversight Committee uncovered bank wires, revealing how the Bidens received millions from Chinese companies with significant ties to Chinese intelligence and the Chinese Communist Party. Just this week, we uncovered 2 additional wires sent to Hunter Biden that originated in Beijing from Chinese nationals. This happened when Joe Biden was running for President of the United States, and Joe Biden's home is listed as the beneficiary address. To date, the House Oversight Committee has uncovered how the Bidens and their associates created over 20 shell companies, most of which were created when Joe Biden was vice president, and raked in over $20 million between 2014 and 2019. We've also identified 9 Biden family members who have participated in or benefited from these shady business schemes. Now, what were the Bidens selling to make all this money? Joe Biden himself. Joe Biden is the brand, and Joe Biden showed up at least 24 times with business targets and associates sending signals of access, influence, and power to those prepared to pay for it. The American people demand accountability for this culture of corruption. They demand to know how these schemes have compromised President Biden and threatened our national security. They demand safeguards to be put in place to prevent public officials from selling access to their public office for private gain. Under the leadership of Speaker Kevin McCarthy, House Republicans have now opened an impeachment inquiry into President Joe Biden. By opening an impeachment inquiry, our investigation is now focused on whether President Biden engaged in impeachable offenses under the U.S. Constitution. It empowers Congress, elected by the people, to continue providing the answers, transparency, and accountability that the American people demand and deserve. In recent history, Democrats inflicted much damage on the credibility of congressional investigations by peddling the Russian collusion hoax. But this committee, under this majority, will not pursue such witch hunts based on manufactured allegations, innuendo, and no real evidence. Today, the House Oversight Committee will examine over 24 pieces of evidence revealing Joe Biden's corruption and abuse of public office. This includes emails, text messages, bank records, and testimony of Biden business associates. We will hear from legal and financial experts about this evidence and crimes that may have been committed as Joe Biden was sold around the world. The House Oversight Committee, along with the committees on the Judiciary and Ways and Means, will continue to follow the money and the evidence to provide accountability so that Americans know their public offices are not for sale. I now yield to Jason Smith, the chairman of the House Ways and Means Committee, for his opening statement.
Thank you, Chairman Comer. Yesterday, the Ways and Means Committee released new documents showing President Biden was not just aware of his son's business dealings, but he was connected to them. In a newly released message to a Chinese business executive, Hunter Biden mentions preserving the, quote, keys to my family's only asset. That asset, Joe Biden. New evidence released in response to questions raised by members of the committee on both sides when Gary Shapley and Joseph Ziegler, the two IRS whistleblowers, testified in July, paints a disturbing picture of a revolving door between Joe Biden's office and Hunter Biden's business partners. According to a worksheet provided by IRS whistleblower Ziegler, then Vice President Biden's April 2014 official visit to Ukraine occurred only days after a series of White House meetings with Hunter Biden and his business associates regarding Ukraine. Shortly after Joe Biden returned stateside, the Ukrainian company Burisma announced Hunter Biden's appointment to its board. New evidence provided shows Hunter Biden using his father's position to gain favor with billionaire Miguel Alemán, including having Joe Biden host them at the White House in February of 2014 at the vice president's residence alongside Mexican billionaire Carlos Slim in November of 2015, and then in 2016 using Air Force Two to shuttle Hunter Biden and his business associate to Mexico City. Whether it was lunches, phone calls, White House meetings, or official foreign trips, Hunter Biden cashed in by arranging access to Joe Biden, the family brand. The Biden family and their associates received millions in payments from foreign sources, including from Russia, China, Ukraine, Romania. In one email, Hunter Biden even bragged that he cut a deal for $10 million from just one company for, quote, introductions alone. And yet the DOJ wanted to keep the spotlight as far from Joe Biden as possible. One of the items we released yesterday was an IRS interview with James Biden, the president's brother, in September of 2022. The agency was barred in the interview from asking him about Joe Biden and about whether Joe Biden was involved in Hunter Biden's deal with a Chinese energy company. And when Hunter Biden had his tax liability of over $2 million mysteriously paid for by a Democrat Party donor named Kevin Morris, who he barely knew, something IRS investigators saw as a possible campaign finance violation, Assistant U.S. Attorney Leslie Wolf said she did not want any of the agents to look into the allegation. On the board are notes Agent Shapley took from that meeting. He notes that Wolf told investigators that she was not, quote, personally interested in pursuing it. This is the same attorney, Wolf, who in an email we released yesterday responded to IRS investigators seeking approval for a search warrant with, quote, there should be nothing about political figure one in here, that being a reference by definition of Joe Biden. The Biden family sold access to Joe Biden's power, and the Biden Justice Department protected the Biden brand. We must continue to follow the facts. I yield to Representative Jordan.
I thank the gentleman for yielding. This is a tale as old as time. Politician takes action that makes money for his family, and then he tries to conceal it. Never forget fundamental facts. Hunter Biden gets put on the board of Burisma. Gets paid a lot of money. Hunter Biden's not qualified, fact number 2, to sit on the board. Not my words, his words. He said he got on the board because of the brand, because of the name. Fact number 3, the executives at Burisma asked Hunter Biden to weigh in and help them with the pressure they are under from the prosecutor in Ukraine. Fact number 4, Joe Biden goes to Ukraine on December 9th, 2015, gives the speech attacking the prosecutor that starts the process of getting that guy fired. Those facts, by the way, are consistent with what the confidential human source told the FBI, and the FBI recorded in the 1023 form, the same form that the Justice Department didn't want to let this committee see. And all those facts, all of that was further confirmed yesterday with the information that the Ways and Means Committee released from the whistleblowers Shapley and Ziegler. Here's a communication from Hunter Biden to an executive with Burisma. Devin and I do feel comfortable with Blue Star strategies and the ability of Sally and Karen to deliver. Hunter Biden put Burisma in touch with Blue Star Strategies. What were they going to deliver? Well, that was in a communication released yesterday as well. U.S. officials in Ukraine and in the United States need to express support for Burisma and Nikolai Zlochevsky to the highest level decision makers, the President of Ukraine, the President's Chief of Staff, and the Prosecutor General. That's what they were going to deliver. And were they successful? The Interior Minister confirmed that Zlochevsky is no longer wanted. We won in less than a year communications between the folks at Blue Star and Eric Sherwin, who was Hunter Biden's business partner. Awesome work. Congratulations to you guys. Those are the communications. That's what they got done. And remember, when this happens in October 2016, when the pressure is taken off, the case is dropped against Zlochevsky, this is the second prosecutor. Joe Biden fired the first one. The second prosecutor comes in, drops the charges. That's exactly what they wanted done. And the final step is the Biden Justice Department tries to sweep it all under the rug. They slow walk the investigation. They let the statute of limitations lapse for the most important years, 14 and 15, the Burisma years when all that income's coming in. They try to put together this sweetheart deal and get it past the judge. And we learned yesterday in the search warrant examining Hunter Biden's electronic communications, they weren't allowed to ask about political figure one. Political figure number one is the big guy, is Joe Biden. And they would have gotten away with it all. They would have gotten away with it all except for two brave whistleblowers who sat in those seats 2 months ago and told their story. And their story has stood up. Two brave whistleblowers and a judge in Delaware who said, we're not going to let this happen. That's why we're here today. That's why this inquiry is so darn important. It's the oldest story in the world, and those are the facts. I yield back.
Gentleman yields back. Chair now recognizes Ranking Member Raskin of Maryland for his opening statement.
Mr. Chairman, thank you. Before I give my opening statement, I have a parliamentary inquiry. Given that the committee has not been authorized by the full House to conduct an impeachment inquiry, am I correct in assuming that we're obligated to follow the rules of the House, including Section 370 of the Rules and Manual, which prescribe engaging in personalities towards the President?
At ease. Well, considering this is an investigation of Joe Biden, I assume that his name's going to come up.
Right, but the House has not authorized us as an impeachment inquiry, so we're just operating with the general rules. And I think saying that the President lied is considered engaging in a personality. In fact, Section 370 says accusations that the President has committed a crime or even that the President has done something illegal are unparliamentary. And we're operating with the general rules of the House because the House has not authorized.
The Speaker of the House has authorized the impeachment inquiry. It has been authorized.
Okay. All right.
Point of parliamentary inquiry.
The ranking member who wants to be recognized, Ms. Ocasio-Cortez.
I believe changing of the rules must require a vote from the full House of Representatives. The rules of the committee.
The chair overrules a point of order. While articles of impeachment are not directly before this committee, we are looking into the potential wrongdoing of the President. Given the unique nature and subject matter of today's hearing topic, these words will not be ruled out of order. So,
okay.
Ranking Member Ashton, please proceed.
Thank you for clarifying, Mr. Chairman. We obviously have an honest disagreement about that. All right, so let's get it straight. We're 62 hours away from shutting down the government of the United States of America, and Republicans are launching an impeachment drive based on a long debunked and discredited lie. No foreign enemy has ever been able to shut down the government of the United States, but now MAGA Republicans are about to do just that. But they don't want to cut off public services to the people and deny paychecks to more than 1 million service members without first launching an impeachment drive, even when they don't have a shred of evidence against President Biden for an impeachable offense. And you think I'm being harsh? Here's what some Republicans have had to say over the last week about the actions of the Republicans as they watch up close, quote, the dysfunction caucus at work, in the words of our GOP colleague from Nebraska, Don Bacon. Clown show, foolishness, terribly misguided, stupidity, failure to lead, lunatics, disgraceful, new low, pathetic, enabling Chairman Xi, people that have serious issues. Those folks don't have a plan, show just how broken they are, and individuals that just want to burn the whole place down. Now, if I said any of these things, they'd probably take my words down, but these are Republicans talking about Republicans. So let's be clear. This isn't partisan warfare America's seeing today. It is chaotic infighting between Republicans and Republicans. It's MAGA versus extreme MAGA, as if anybody in the real world could tell the difference between the two. What a staggering failure of leadership. Speaker McCarthy's invertebrate appeasement of the most fanatical elements of his conference now threatens the well-being of every American. Now, some people think the members of the GOP caucus aren't interested in anything logical. They just want to see the world burn, as Alfred Pennyworth put it in The Dark Knight. But I see a method in the madness. A week ago, Donald Trump posted a comment saying that a government shutdown, quote, is the last chance to defund these political prosecutions against me and other patriots. You get it? To delay justice, Donald Trump would cut off paychecks to a couple million service members and federal workers and furlough more than 1 million workers and pay them later for having not worked. They would halt food assistance to millions of moms and kids and keep NIH in my district from enrolling any more patients in life and death clinical research trials. Trump's convinced that if we shut the government down, his 4 criminal prosecutions on 91 different felony and misdemeanor charges will be defunded and delayed long enough to keep him from having to go before a jury of his peers before the 2024 election. And like flying monkeys on a mission for the Wicked Witch of the West, Trump's followers in the House now carry his messages out to the world: shut down the government, shut down the prosecutions. But the cult master has another command for his followers, which brings us here today. On August 27th, he posted this edict: either impeach the bum or fade into oblivion. They did it to us. Of course, the standard for impeachment is not whether they did it to us, but whether the president committed treason or bribery or other high crimes and misdemeanors. But the Constitution's irrelevant to them. What is what Donald Trump wants. As Republican Representative Ken Buck, a Freedom Caucus member, told CNN the other day, President Trump has gone on his social media account and said we should be impeaching President Biden. Kevin McCarthy said we have an impeachment inquiry. You draw the conclusion, directly or indirectly, this impeachment inquiry was a result of President Trump's pressure. So we move from a Trump-ordered government shutdown to a Trump-ordered impeachment process, and yet back in the reality-based world, the majority sits completely empty-handed with no evidence of any presidential wrongdoing, no smoking gun, no smoke. In fact, we have had to slide awkwardly into a House impeachment process without the benefit of the floor vote that Speaker McCarthy insisted was absolutely imperative and necessary when Donald Trump was impeached. In fact, they went to the Department of Justice and they got an OLC opinion saying, quote, no committee may undertake the momentous move from legislative oversight to impeachment without the delegation by the full House of such authority. OLC opinion, January 19th, 2020. And that's why the House voted in the case of Donald Trump, but that's exactly what has not happened here because they don't have the votes, because dozens of Republicans recognize what a futile and absurd process this is. Now, the title of the hearing is The Basis for an Impeachment Inquiry of President Joseph Biden. And yet, they present us no basis at all today, even after 8 months of investigation. They've invited 3 witnesses to testify. Not one of them is an eyewitness to a presidential crime of any kind. Not one of them is a direct fact witness about any of the events related to Ukraine and Burisma. Not one of them has participated in the 8 months of investigation in which our distinguished chairman has publicly boasted that he received 100% of everything he asked for. And I quote, "Every subpoena that I've signed as chairman of the House Oversight Committee over the last 5 months, we've gotten 100% of what we've requested, whether it's with the FBI, with the banks, or with Treasury." That means we are the real witnesses here. In fact, the committee has received 12,000 pages of bank records. Here they are, right in front of us, printed double-sided. And not a single page shows a dime going to President Joe Biden. We've received 2,000 pages of SARS reports the chairman subpoenaed. We've held hearings and conducted interviews with everybody from Hunter Biden's business partners to a federal agent assigned to that investigation, and still we found no evidence of wrongdoing by President Biden. If the Republicans had a smoking gun or even a dripping water pistol, they would be presenting it today, but they've got nothing on Joe Biden. All they can do is return to the thoroughly demolished lie that Rudy Giuliani and Donald Trump launched 5 years ago, the Burisma conspiracy theory, a fairy tale so preposterous that one of its main authors, Lev Parnas, has now disowned and repudiated it. This is the theory that Vice President Biden, global anti-corruption groups, and most Western governments targeted Ukraine Prosecutor General Shokin for removal because he was threatening the Burisma Corporation, whose board Hunter Biden served on. Trump synthesized the lie in his August 27th post about President Biden, saying, look, the guy got bribed. He paid people off, and he wouldn't give $1 billion to Ukraine unless they, quote, got rid of the prosecutor. Trump's story is the opposite of the truth. When Biden was VP, he worked as a key player in the Obama administration and global community's efforts to combat corruption in Ukraine. In late 2015, as part of a coordinated global effort, Biden called for the removal of Viktor Shokin, a corrupt Ukrainian prosecutor general who did nothing about corruption in Ukraine other than to participate in it, rather than assist British authorities who were actually investigating Burisma and its owner. Shokin consistently frustrated their efforts. The leadership provided by Biden was part of a broad bipartisan campaign to oppose corruption in Ukraine. In early 2016, Republican senators Ron Johnson, Rob Portman, and Mark Kirk wrote to the Ukrainian president assailing corruption in his country and urging him to press ahead with urgent reforms to the Prosecutor General's office. Yet years later, in 2018, as President Trump saw Biden as a strong rival in the 2020 election, he worked with Giuliani to twist all the facts around and to suddenly accuse Biden of corruption in calling for the dismissal of a corrupt prosecutor. A few months ago, Chairman Comer and the committee received an insider's account of the plan to concoct and spread this lie from an extraordinary letter sent to us by Lev Parnas, who was Rudy Giuliani's right-hand man. Giuliani and Parnas searched high and low to find anyone who would endorse their contortions about Biden. Their failing crusade culminated in the infamous phone call that then President Trump made to Ukrainian President Zelensky, in which Trump threatened to withhold hundreds of millions of dollars in economic, strategic, and military security assistance to Ukraine unless Zelensky embraced their ridiculous fabrication and falsely advertised to the world that Ukraine was investigating Joe Biden. This shakedown became the basis for the first House impeachment of President Trump. Giuliani's big lie has been thoroughly debunked by multiple sources. As Congressman Buck, a former chief of the criminal division of the U.S. Attorney's Office in Colorado and a member of the House Freedom Caucus said, and I quote, "There is in fact no evidence that Shokin was engaged in an investigation of Burisma or that Joe Biden's role in his firing was in any way connected to Burisma." He continued, "What's missing, despite years of investigation, is the smoking gun that connects Joe Biden to his never-do-well son's corruption." It's scandalous to use impeachment to establish a counterfeit moral equivalence between President Biden, an honorable public servant who has never been indicted or convicted of anything in his career of more than 50 years in public life, and Donald Trump, a twice impeached president who's recently been found in court to have sexually abused and defamed a woman and fraudulently inflated the value of his real estate properties while facing 91 criminal charges in 4 separate indictments on everything from conspiring to overthrow an election and defraud the American people to making criminal hush money payoffs to stealing classified government documents and hiding them while obstructing justice. Impeachment is the people's final weapon of constitutional self-defense against a president who behaves like a king and violates the public trust by committing treason, bribery, or other high crimes and misdemeanors equivalent to them. It is reserved for extraordinary public offenses like inciting a violent insurrection against the American government and trying to overthrow our presidential election. That offense in 2021, whose related crimes have resulted in hundreds of criminal convictions and hundreds more being prosecuted, led to Donald Trump's second impeachment in the House on a massive bipartisan vote of 232 to 197 and a similarly lopsided bipartisan vote of 57 to 43 in the Senate. I wonder how many of my esteemed Republican colleagues here who all voted against impeaching Donald Trump, if they were in the House at that point, can reconcile their votes against impeaching Trump for the grave crime of inciting a violent insurrection against the government with their calls supporting impeachment of Joe Biden for allegedly committing a high crime and misdemeanor that has not even been defined yet, much less proven. Mr. Chairman, if this dysfunction caucus is going to insist on going forward, we must receive the testimony of Rudy Giuliani and Lev Parnas, the insiders who know the origins of the lie upon which this sham impeachment is based and who work to spread it. We know that Mr. Parnas is ready and willing to testify, and as a former U.S. Attorney and Mayor, Mr. Giuliani will surely agree to enlighten us on everything. Pursuant to Clause 2K6 of Rule 11, I move that the committee subpoena Rudy Giuliani and Lev Parnas come and testify in these hearings. And I would like to ask for a vote on that or debate, as you would please, Mr. Chairman.
You made a motion to subpoena.
Are they going to table it? I didn't hear a motion to table.
Motion, yeah. Mr. Chairman. Chair recognizes Mr. Jordan.
I move to table the motion.
There's a motion to table Mr. Raskin's motion. Is there a second?
I'd like to ask for a recorded vote on that, Mr. Chairman. This is on the subpoena of the 2 key figures, Rudy Giuliani and Lev Parnas.
Key figures for what?
But in your theory about why President Biden should be impeached, I think
This is going to be an informative hearing for you, Mr. Raskins, because we were going to present evidence.
What evidence? There's no evidence witnesses.
Well, just,
there are no fact
just
witnesses.
sit back and let the American people see the hearing and let the American people decide.
All right.
Now, look,
All right.
you've gone over your time. We're going to have a
There's a motion to
we're going to
table
go
on
by
the
the
floor.
rules here.
Okay.
Okay?
Motion to
And I'm glad you brought the box of bank statements. If we had a box of all the foreign money the Bidens took, it would have reached to the ceiling.
Yeah.
So let's just
A
have
point
this
of parliamentary
hearing.
inquiry.
No, listen. Everybody's going to get 5 minutes. I'm going to present the witnesses. Everyone's going to get a chance. 5 minutes. I'll let the ranking member go way over time in his opening statement, but we are going to abide by the 5 minutes.
There's a motion to table on the floor.
There's a motion
There's
on
a
the floor.
motion on the floor.
Roll call. Clerk will
There's a non-debatable motion on the floor.
call the roll.
On the motion to table. Right. Will the clerk, we don't even have a clerk. Okay. Will the clerk get prepared for the roll call? Mr. Raskins made a motion, and then Mr. Jordan made a motion to table, and was seconded. So the vote will now be on the motion to table Mr. Raskins' motion to subpoena Rudy Giuliani
And Lev Parnas.
and Les Parnas. All right. Will the clerk take the roll?
Neither Mr. Giuliani nor Mr. Parnas is in jail now.
Nate. This is the motion to table Mr. Raskin's motion.
Mr. Jordan?
Yes.
Mr. Jordan votes aye. Mr. Turner? Mr. Gosar? Ms. Fox? Mr. Grothman? Mr. Palmer? Mr. Higgins? Mr. Sessions? Mr. Sessions votes aye. Mr. Biggs? Mr. Biggs votes aye. Ms. Mace? Ms. Mace votes aye. Mr. LaTurner? Mr. LaTurner votes aye. Mr. Fallon? Mr. Donalds? Mr. Donalds votes yes. Mr. Armstrong? Mr. Armstrong votes yes. Mr. Perry? Mr. Timmons? Mr. Timmons votes aye. Mr. Burchett? Mr. Burchett votes yes. Ms. Green? Ms. Green votes aye. Ms. McLean? Ms. McLean votes aye. Ms. Boebert? Ms. Boebert votes aye. Mr. Fry? Mr. Fry votes aye. Ms. Luna? Mr. Edwards? Mr. Edwards votes aye. Mr. Langworthy? Mr. Langworthy votes aye. Mr. Burleson? Mr. Burleson votes aye. Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Norton?
No.
Ms. Norton votes no. Mr. Lynch?
No.
Mr. Lynch votes no. Mr. Connolly?
Nay.
Mr. Connolly votes nay. Mr. Krishnamurthy?
Nay.
Mr. Krishnamurthy votes nay. Mr. Khanna?
No.
Mr. Khanna votes no. Mr. Mfume?
Fume votes no.
Mr. Mfume votes no. Ms. Ocasio-Cortez?
Nay.
Ms. Ocasio-Cortez votes nay. Ms. Porter? Ms. Bush? Mr. Gomez? Mr. Gomez votes no. Ms. Brown? Ms. Brown votes no. Ms. Stansbury?
No.
Ms. Stansbury votes no. Mr. Garcia?
No.
Mr. Garcia votes no. Mr. Frost?
No.
Mr. Frost votes no. Ms. Lee? Ms. Lee votes no. Mr. Kassar?
No.
Mr. Kassar votes no. Ms. Crockett?
No.
Ms. Crockett votes no. Mr. Goldman?
Nay.
Mr. Goldman votes nay. Mr. Moskowitz? Mr. Moskowitz votes no. Ms. Tlaib? Ms. Tlaib votes no. Mr. Chairman? Mr. Chairman votes yes. Mr. Gosar is not recorded. Mr. Gosar votes yes.
How has Mr. Fallon been recorded?
Mr. Fallon is not recorded. Mr. Fallon votes yes.
Okay. Hold for one. Let's see.
Regular order, Mr. Chairman. Mr. Chairman, a request for regular order.
We're seeking regular order, Mr. Chairman.
We have members en route to vote. How is Mr. Palmer recorded?
Mr. Palmer is not yet recorded. Mr. Palmer votes aye.
Motion to close the vote.
Mr. Chairman?
Second.
Mr. Chairman? How is my vote recorded?
Has Ms. Green been recorded?
Ms. Green is voted aye.
Mr. Chairman,
Chair recognizes Mr. Timmons.
how am I recorded?
Mr. Timmons is voted aye. Ms. Boebert has voted aye.
Mr. Chairman? Mr. Chairman?
Yes. Chair recognizes Mr. Fallon.
How am I recorded?
Mr. Fallon is voted aye.
Mr. Chairman, parliamentary inquiry. Mr. Chairman, there was a motion to close the vote, and it was properly seconded.
There is, will the clerk call the roll?
Mr. Chairman, on this vote, the ayes are 20, the nays are 19.
The motion passes to table the Raskins motion. Now, I'm pleased to welcome an expert panel of witnesses who each bring experience and expertise to today's hearing. I'd first like to welcome Professor Jonathan Turley, who is the Shapiro Chair for Public Interest Law at George Washington University Law School. Professor Turley is a nationally recognized legal scholar who has published work in areas ranging from constitutional law to legal theory. Next, we have Ms. Eileen O'Connor, who is a former Assistant Attorney General at the United States Department of Justice Tax Division. As former Assistant Attorney General for DOJ Tax for 6 years, Ms. O'Connor supervised DOJ litigation of civil, criminal, trial, and appellate tax cases. Next, we have Mr. Bruce Dubinsky, who is the founder of Dubinsky Consulting, a forensic accountant. Mr. Dubinsky has accumulated over 40 years of financial, investigative, and dispute consulting experience, served as an expert witness over 100 times, and has testified in over 80 trials, including trials involving criminal and civil financial fraud. Lastly, we have Professor Michael Gearhart, who serves as the Burton Craig Distinguished Professor at the University of North Carolina, Chapel Hill. Professor Gearhart has been a law professor for more than 30 years. He's the author of 7 books and has written more than 100 law review articles and dozens of op-eds in the nation's leading news publication. Pursuant to Committee Rule 9G, the witnesses will please stand and raise the right hand. Do you all solemnly swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth, so help you God? Let the record show that the witnesses all answered in the affirmative. Thank you all. You may be seated. We appreciate you all being here today and look forward to your testimony. Let me remind the witnesses we have read your written statements and they will appear in full in the hearing record. Please limit your oral statements to 5 minutes. As a reminder, please press the button on the microphone in front of you so that it is on and the members can hear you. When you begin to speak, the light in front of you will turn green. After 4 minutes, the light will turn yellow. When the red light comes on, your 5 minutes is expired, and we would ask that you please wrap up your testimony. I now recognize Professor Turley to begin his opening statement.
Thank you, Chairman Comer, Ranking Member Raskin, members of the committee. It's an honor to appear before you today to talk about what is undoubtedly the most weighty constitutional decision that you have under Article 1, other than the declaration of war, and that is the potential impeachment of a President of the United States. It was roughly 25 years ago that I appeared in the impeachment proceedings with other experts in the impeachment of President William Clinton. It was 4 years ago that I appeared in the impeachment proceedings for President Donald Trump. And then it was just 3 years ago that another impeachment occurred without any hearings at all. The shortening intervals between impeachments should be a cause of concern and circumspection for all the members on both sides. And I want to emphasize what it is that we're here today for. This is a question of an impeachment inquiry. It is not a vote on articles of impeachment. In fact, I do not believe that the current evidence would support articles of impeachment. That is something that an inquiry has to establish. But I also do believe that the House has passed the threshold for an impeachment inquiry into the conduct of President Biden. Having said that, I want to just address 3 inescapable facts that led me to that conclusion. First, President Biden has indeed spoken falsely about these foreign deals. The Washington Post and other newspapers have noted that some of his past comments are demonstrably untrue. Second, President Biden was the focus of a multi-million-dollar influence peddling scheme. And then finally, President Biden may have benefited from millions of dollars as a part of that scheme. Now, those facts should not be taken out of context. They're merely allegations, and they should not become presumptions of impeachable conduct. Indeed, as I've said in past impeachments, self-dealing is a difficult issue under the impeachment clause The framers sought to avoid ambiguous standards. That's one of the reasons that perfidy was rejected. While it may not sit well with many, President Biden and other presidents can be dishonest, can even lie to the American people, and that would not constitute an impeachable offense. Indeed, most presidents have lied to the American people. That's why I've not liked any president since James Madison. Now, dishonesty alone is not impeachable, and so what I lay out in my testimony are what I call guardrails or best practices. Those are designed to protect this process. Frankly, a number of the things I lay out benefit President Biden, as I say in my testimony. Because presidential impeachment shouldn't be a closed question, it shouldn't be a rush to judgment, and you should avoid the type of confirmation bias that can occur in this process. This is, as people say, a political process, but it is also a constitutional process. Influence peddling is a form of corruption. The United States has signed treaties to combat this form of corruption around the world. And that is also an inescapable fact. We need to find answers as to some of these questions. I'm running out of time, so I'd like to make one last observation, if I may. These are constitutional moments that demand the best from each of us to transcend the politics and passions of our time. It calls for something that's difficult. It calls for solemnity and clarity for members. We have become a nation addicted to rage, and we can fuel that. This body is a powerful teacher, as Brandeis said, and you can teach that, or you can teach a respect for this process. It begins here and now. We can disagree with each other without hating each other. These are important issues, and I think they're close issues. And I think some of these issues really do gravitate in favor of the president. So I would simply say that this is a moment where members and citizens can stand together without prejudging the evidence. And I thank you for the honor of appearing before you today.
Thank you, Professor Turley. Ms. O'Connor.
Mr. Chairman, Ranking Member, members of the committee, the chairman invited me to share my thoughts on the conduct of the tax investigation into Hunter Biden. I make my comments on my own behalf as a private citizen and not on behalf of any person with whom or group with which I might be or have been affiliated. When I learned that experienced IRS special agents had been compelled to report to Congress about the obstruction of their criminal tax investigation, I felt compelled, too, to share my understanding of how things are supposed to work with people who have no reason to appreciate how disturbing the whistleblower's allegations are. Without context and a frame of reference, it's difficult to know sometimes how seriously to take things. In an October 2022 meeting of the Hunter Biden prosecution team, U.S. Attorney Weiss admitted it was not his decision whether to bring charges the investigation had proven should be brought. This directly contradicted Attorney General Garland's sworn testimony 6 months earlier. This was the final straw. After more than 3 years of having his investigation stymied, but nonetheless having proven substantial criminal charges, Supervisory Special Agent Shapley realized he had to come forward. In fact, he had come forward before, internally within the IRS, using the procedures developed for that purpose. He had complained up his chain of command as early as June 2020 about the obstruction he was encountering, but there had been no response. Once Shapley had taken steps to come forward to Congress, Special Agent Joseph Ziegler did the same. It was not the whistleblower's testimony, however, but what followed that compelled me to write. My first Wall Street Journal article was called "Throw Hunter Biden's Plea Deal in the Trash." Given the substance of the whistleblower's testimony, the plea deal Weiss had worked out with Biden was a miscarriage of justice. After that commentary was published, I heard from many people who were similarly appalled at the unfolding injustice. Many were knowledgeable and experienced tax professionals. Perhaps the most commonly commented on aspect of the handling of the Hunter Biden matter was that Weiss had permitted the statute of limitations to expire on prosecuting provable offenses. This was appalling. It is not significant that the plea agreement, it is not insignificant that the plea agreement was announced on June 20. Let's review what came just before. On August 19, it became known that IRS employees were going to let Congress know about the obstruction they were encountering. Later, Shapley and Ziegler sat for hours of sworn and subscribed testimony with the House Ways and Means Committee staff. It was expected that the committee would make the testimony public. It did, on June 22. U.S. Attorney Weiss, with his June 20 announcement of a plea deal, beat the publication of the whistleblower's testimony by the skin of his teeth, 2 days. If the whistleblowers had not come forward, would Weiss have brought any charges at all? My second Wall Street Journal commentary was published on July 25. It was called "You'd Go to Prison for What Biden Did." Given what Shapley and Ziegler testified they had proven, and the charges the tax division reportedly had authorized, the plea deal represented serious injustice, not only to law enforcement, but also to people who have been caught up in this system and have suffered the consequences the law provides. I received a great deal of positive feedback on this commentary, too. People understand that for laws to be respected, they must be enforced. The nature of any investigation is the following of leads. That didn't happen here. This team was not permitted to search the guest house of Joe Biden's Delaware mansion and Hunter Biden's storage facility in Virginia, to interview family members and business associates, to examine Hunter Biden's abandoned laptop. By November 2019, the FBI had confirmed the devices were Hunter's and the contents were authentic. But the Hunter Biden investigation must not be viewed in isolation, rather as part of a broad landscape of corruption. Don't forget that a full year after that, in October 2020, FBI officials were telling Twitter that the laptop was Russian disinformation. The whistleblowers tell us that the tax investigation of Hunter Biden was an offshoot of an investigation already underway into an online pornography platform. That is how investigations develop. Agents follow wherever the leads take them, and when they take them in the direction of a new investigation, they open one. Question: if U.S. Attorney Weiss had been in charge of that pornography investigation, would he have blocked the investigation into Hunter Biden's tax crimes? I thank the committee.
Thank you, Ms. O'Connor. Mr. Dubinsky.
Good morning, Chairman Comer, Ranking Member Raskin, distinguished members of this committee, guests, and my fellow citizens. Thank you for this opportunity to testify today. First, at the outset, let me state unequivocally and in no uncertain terms that I agreed to testify today not because I have a political agenda or axe to grind, because I do not. Rather, I agreed to testify in this proceeding in order to help this committee and the American people gain a better understanding of how frauds are committed, how complex business arrangements using limited liability companies, sometimes those being shell companies, are used in frauds, and how money is moved by fraudsters to facilitate the conduct of illicit activity. Let me be clear, I am not prejudging the facts that have emerged to date with regard to the Biden family and associates businesses and the money they received that had its origins from foreign sources. I am not here today to even suggest that there was corruption, fraud, or any wrongdoing. In my opinion, more information needs to be gathered and assessed before I would make such an assessment. I'm here today to lend my expertise to answer questions that this committee may have while they advance this investigation and gather more facts about the business dealings surrounding the Biden family and associates businesses. Throughout my 40-year career as a certified public accountant, a forensic accountant, and a certified fraud examiner, I've worked tirelessly to uncover the truth when it comes to cases involving allegations of fraud, corruption, and wrongdoing. I have investigated some of the world's largest frauds, including have investigated and testified in the criminal case for the United States Department of Justice on the Bernie Madoff Ponzi, the world's largest Ponzi. I've worked on cases like the Enron case, the International Brotherhood of Teamsters election corruption cases, as well as some of the United States' largest cases of tax fraud, to name a few. As the age-old proverb goes, where there's smoke, there's fire. As a fraud investigator, when I see smoke, I immediately look for the fire. The critical question facing the American people today is whether behind the smokescreen clouding the Biden family and associates businesses, was there or is there a fire? And if there was or is a fire, how big is that fire? Why were members of the Biden family and close business associates receiving millions of dollars of payments from foreign entities and individuals? What services, if any, were being provided? What was the substance of the alleged services being provided? Was the money being paid for a fair amount commensurate with those services? Were political favors being traded and disguised as services? These are the questions that, as a forensic accountant, I routinely am asked to answer when I'm hired to investigate allegations of corruption and fraud. There's a great deal of evidence that has been collected to date by this committee and others trying to answer these very questions. However, much more information is still needed in order to be able to answer these questions and make a final determination as to whether or not the Biden family and its associates' businesses were involved in any improper or illicit activities, and importantly, whether those activities, if any, were connected to President Joe Biden or then Vice President Biden. In my experience, fraudsters purposely create a labyrinth of limited liability companies to create an opaque network of entities that are then used to hide improper conduct. In many instances, these complex business arrangements are typically centered around illicit activities and involve moving money around the globe in a manner designed to avoid the detection of the underlying illegal activity, as well as the movement of the money tied to that illegal activity. Gone are the days, for the most part, when suitcases full of currency or gold bars are exchanged as payment in the conduct of illegal activities. Today, more sophisticated methods are employed to obfuscate the true nature of such illegal activities and to hide the movement of money. The importance of following the trail of money is a critical component of any fraud investigation. The term shell company has its origins in the world of business and finance. The term shell, as you would note, implies that the company is like an empty shell, lacking substance or real activity. Shell companies typically have no employees, no offices, no real operating businesses. They use P.O. boxes for mailing addresses. While I will note shell companies can be used for legitimate business activities, more often than not, they're associated with fraudulent activities like tax evasion, money laundering, hiding of assets, and other illicit practices. It takes a heavy lift to pull the covers back on these shell companies to determine who the true beneficial owners are, where the money went, and to expose the true sham nature of their existence. However, through the use of legal subpoenas and proper investigative methods and a great deal of persistence, fraud investigations can and do expose the identity of the wizards behind these curtains and the extent of their illicit activities. In closing, let me underscore the importance of conducting a thorough, independent, and unbiased investigation of the matter before us today before you reach any conclusions. The American people deserve to know the truth. The rigor and discipline of a well-planned and executed investigation should not be subverted by political motivations or aspirations. To do so would critically undermine the integrity of any such investigation and any conclusions reached. Thank you again for this opportunity to be here today, and I look forward to answering your questions.
Thank you very much. Professor Gerhardt.
Thank you, Mr. Chairman. I want to thank the ranking member as well and distinguished members of this committee. I appreciate the honor and the privilege to be able to appear before you today to talk about the basis for an impeachment inquiry of President Biden. I think a good place to begin is with the Federalist Papers. And in the Federalist Papers, Alexander Hamilton warned of the dangers of trivializing impeachment through petty partisanship. He foresaw that impeachment may, and now I quote, agitate the passions of the whole community and to divide it into parts more or less friendly or inimical to the accused. In many cases, it will connect itself with pre-existing factions and will enlist all their animosities, partialities, influence, and interest on one side or on the other. And in such cases, there will always be the greatest danger that the decision will be regulated more by the relative strength of the parties than by demonstrations of innocence or guilt. I think Alexander Hamilton knew what he was talking about, and I think what he said may well describe the current set of proceedings. One thing I might add to all of that is that the framers designed an impeachment process to follow or comply with several safeguards. And it's important that we keep these safeguards in mind as these proceedings go on. The first is the necessity for credible evidence of the commission of treason, bribery, and other high crimes and misdemeanors. There is not, at least not that I've yet heard, such credible evidence. Let me give you an example of what I fear is similar to the current proceedings. Hunter Biden is arrested for speeding in a car owned by his father, and the police go after the father. I don't think that's how the law should work. I don't think that's how impeachment should work. I respect members of this committee enormously. Believe me, I'm just a law professor and citizen, and I come here with great awe when I speak to an important body like this. But I listened to Congressman Jordan, whom I respect a great deal, when he said there are 4 facts. Hunter Biden was on the board of Burisma. Hunter Biden was not qualified. So far, by the way, nothing about President Biden. Third, there were executives who asked Hunter Biden for help. Again, not yet any proof about any kind of complicity of President Biden. And lastly, Joe Biden gave a speech. If that's what exists as a basis for this inquiry, it is not sufficient. I say that with all respect, and I think that that is part of the problem, I think, and many Americans think, may exist with respect to these proceedings. A second safeguard is the Fifth Amendment Due Process Clause. It requires fundamental fairness. And I think in these proceedings, something has happened to President Biden that was said to have happened to President Trump in 2019. And that is, the burden has flipped to President Biden to prove his innocence. Any further investigation is being done to ensure that Mr. Biden has to prove his innocence rather than the committee being able to connect the dots in a convincing and persuasive way. It's not me you have to persuade. It's the American people whose trust you deserve and whose trust you have to maintain. A third principle is judicial review. And here I would just remind the committee about the Supreme Court's decision in Trump versus Mazars. The court said about this committee that, in fact, it has to conduct an investigation for a legitimate purpose. A fishing expedition is not a legitimate purpose. Moreover, the court in Trump versus Mazars said that it is not a legitimate purpose for the House or House committee to be conducting the function of law enforcement. And I heard many references here to criminal misbehavior, to whether or not somebody should be thrown in jail, criticisms of a prosecutor, Mr. Weiss. That sounds to me like an attempt to really substitute for the proper legitimate proceedings of the House. Two other safeguards real quickly. One is that these proceedings should be based on principle, not partisanship. And I fear that what we're hearing today, which can be traced all the way back to 2019, and accusations made against Mr. Biden as far back as then, are really driven by partisan animus more than they are by principle. And a final safeguard is for the House, the full House, to authorize an impeachment inquiry. That does not come from me. That comes from Speaker McCarthy. He said there should be the full House's approval. It also comes from Mr. Trump's Justice Department, who said there must be a committee must be authorized by the full House. That has not happened here. My concern is with the Constitution. That's what my devotion is to. And I hope all of us understand that there's nothing more serious than honoring our Constitution and following the design the framers gave us. Thank you.
Gentleman's time has expired. I do want to state the fact in 2019, the D.C. District Court judge ruled a vote of the full House was not required to commence it. Now we're going to begin the question and answer phase. We have 47 members here today that are going to ask questions, so we're going to abide by the 5 minutes. I will begin, followed by Ranking Member Raskins. This week, the Oversight Committee issued another bank subpoena targeting specific wires originating from Beijing. Most of our bank subpoenas have been for Biden family associates' accounts, resulting in thousands of pages of bank records. We've identified these bank accounts based on suspicious activity reports filed with the Treasury Department after being flagged by the banks. The bank records obtained this week showed that on August 2nd, 2019, Jonathan Lee and Ms. Tang Ling in Beijing sent Hunter Biden $250,000, listing Joe Biden's home address in Wilmington, Delaware. The wire stated it was for a personal investment. A second wire showed that on July 26, 2019, Ms. Wang Xin sent $10,000, listing Joe Biden's home address in Wilmington, Delaware. The $10,000 wire said it was a loan to beneficiary. Now let's talk about the $250,000 personal investment. Sure looks like Jonathan Lee was making a substantial investment in the Bidens months after Joe Biden announced his run for the presidency in April 2019. Now, who is Jonathan Lee? During Devin Archer's interview with the Oversight Committee, he explained how Vice President Biden developed a relationship with Jonathan Lee. Vice President Biden had coffee with Jonathan Lee in Beijing. He talked with him on the phone and even wrote a college recommendation letter for Mr. Lee's children. Hunter Biden even met with Jonathan Lee after flying on Air Force Two to Beijing with Joe Biden. The Beijing Bidens cultivated a relationship with Jonathan Lee and other Chinese nationals for one reason and one reason only: to access their wealth. As we all know, the Bidens had nothing to sell except the brand, which was Joe Biden. Hunter Biden sold the brand well, making the Biden family millions from China and elsewhere. While Joe Biden was vice president, Hunter Biden became an investor in a Chinese investment fund with Jonathan Lee and owned a percentage of BHR Partners through one of his many LLCs. This was a political problem for his dad, the big guy, who was running for president. In October 2019, 2 months after the Beijing wires, Hunter Biden's lawyer claimed he served only as a member of the board of directors in an unpaid position. This was Hunter Biden's lawyer. He was in an unpaid position. Abby Lowell now claims the money is a documented loan from a private individual. Now, these wire statements are very concerning, and the Biden's defenders' justification for the money isn't consistent with what we know from the suspicious activity reports from Treasury. Mr. Dubinsky, I'm very skeptical of Abby Lowell's statement that the $250,000 payment from Jonathan Lee and another woman was a loan, because the wire states it was a personal investment. We've also reviewed documents at Treasury that don't support Mr. Lowell's theory. In your experience, are international loans of this amount supported by documentation such as loan terms, interest rates, and repayment schedule?
Yes, Mr. Chairman. They typically would be. You would see that. You would see documents setting forth the interest rates, terms of repayments,
Absolutely.
all of those.
Absolutely. So would it be important to review Hunter Biden's bank records and see if Hunter Biden paid back the money to Jonathan Lee, or if he sent the money to someone else, I don't know, using a cashier's check, for example?
Well, as somebody mentioned earlier, it's very important to follow the money.
Absolutely.
And that's very important in this situation.
Thank you. Professor Turley, we all know what this payment's really for. It's for influence peddling and selling the Biden brand. Now, to date, we have shown that the Biden family and their companies received more than $15 million without providing any known legitimate services between 2014 and 2019. If you include the business associates in their companies, they've received over $24 million. Based on evidence we've developed so far, what are some of the potential laws we should be analyzing during our impeachment inquiry?
Thank you, Mr. Chairman. I actually lay out what are the most obvious potential articles of impeachment without saying that those have been established, but the ones that I recommend for the committee to focus on. And one of the things I recommend is that the committee actually start by looking at potential crimes, because I've said that in the past two impeachments, that it's an important thing to front-load criminal acts for the reasons I laid out. It gives a very high standard for impeachment, quite frankly, higher than it's binding. I said in the last two impeachments, you can't impeach for non-criminal conduct. So I suggest starting there. But as I talk about in my testimony, bribery, obstruction, conspiracy, abuse of power, those have all been raised in past impeachments. Abuse of power is the article that is common. It tends to be a catch-all, and it is the one that I've always been a little bit uncomfortable with, which is why I suggest you end there rather than start there, because that's the article that brings in a lot of non-criminal conduct. And frankly, I think that you need to focus as much as you can on the evidence and whether you can establish these connections.
Very good. Thank you. Chair now recognizes Mr. Raskins of Maryland for 5 minutes.
Thank you, Mr. Chairman. Professor Gerhardt, has there ever been an impeachment process launched in the middle of a government shutdown?
No.
Well, why did the Office of Legal Counsel opine that there must be a vote of the full House before a committee launches into an impeachment investigation? Why did Speaker McCarthy insist on it and, in fact, say that there would be one in this case?
I think the Office of Legal Counsel said that, at least in part, because an impeachment inquiry is deadly serious. It is, again, just about the most serious thing any House committee ever undertakes. And one safeguard against a committee acting on the basis of just, let's say, the party membership is to ensure that the full House is behind the impeachment inquiry.
A dozen of our colleagues on the Republican side have already called for impeachment. I'm struck by the fact that of the 4 expert witnesses brought together today, not a single one of them argued that a sufficient quantum of evidence exists today to justify the impeachment of President Biden. Is there any precedent in our country for launching an impeachment inquiry absent evidence of wrongdoing by the president?
No. And in fact, I would just point out that with Richard Nixon and Bill Clinton and President Trump in 2019, the full House authorized those impeachment inquiries.
Lev Parnas sent us a letter in which he said, it was addressed to Chairman Comer, in which he said, the narrative you are seeking for this investigation has been proven false many times over by a wide array of respected sources. There is simply no merit to investigating this matter any further. And he says, please abandon this effort to investigate the Bidens, which is nothing more than a wild goose chase. And he was Rudy Giuliani's right-hand man, gallivanting all over the world to try to put together a case back in 2019 that Joe Biden had done something wrong. Do you agree that, given that the evidence we've looked at over the 8 months comes down to this discredited Burisma conspiracy theory, we should hear from those responsible for concocting the story in the first case, in the first place, specifically Lev Parnas and Rudy Giuliani?
Absolutely.
What did you think about the fact that the very first act of the committee in its impeachment investigation was to reject the idea of subpoenaing Lev Parnas and Rudy Giuliani, who are at the heart of the story that's the basis for impeachment?
I think if there's going to be an investigation into the president, all the evidence, that is to say, all the participants, anyone that has knowledge, should be spoken to.
We have lots of colleagues on this committee and off the committee who've called for the impeachment of Joe Biden, who also voted against impeaching Donald Trump for inciting a violent insurrection against the Union. And hundreds of people have gone to jail in subsidiary acts under the umbrella of that insurrectionary process. Now, can you come up with a theory that it would allow someone to say, I am going to vote to impeach Joe Biden for offenses unstated and evidence unknown, but I will oppose and vote against the impeachment of Donald Trump for inciting a violent insurrection against the Union, which is something that concurrent bipartisan majorities voted for in the House and the Senate?
I cannot, and I might just add as a law professor that one of the things I suggest to my students in trying to assess the constitutionality of any governmental action is to take the names out, switch the names or switch the political parties and see if the outcome is the same.
So if Joe Biden had incited a violent insurrection against the Union and said, you go and fight like hell, and if you don't, you won't have a country anymore, would you consider that in the ensuing mayhem and chaos
Absolutely.
To be an impeachable event?
Absolutely.
Or, to your mind, in applying the law to the facts, have you seen any evidence that Joe Biden has done anything remotely comparable to what Donald Trump did, which earned him his impeachment in the bipartisan vote of the House?
I have not, and I also just might add, with all due respect, I heard the phrase Biden family many, many times, but I don't know who the Biden family is. I don't know who's being referenced when people talk about the Biden family.
Thank you, Professor Gerhardt. Mr. Chairman, I'd like to move for unanimous consent to introduce Lev Parnas' July 18th, 2023 letter to you and to me and to the rest of the committee into the official record of this proceeding.
Without objection, so ordered. Chair now recognizes the chairman of the House Ways and Means Committee, Jason Smith from Missouri, for 5 minutes.
Thank you, Mr. Chairman. It's amazing to be sitting in your committee. It's a pleasure to be here. Yesterday, we had a committee to release over 700 pages of documents that came from the 2 IRS whistleblowers based on the last oversight hearing when they presented before this committee, where members, both Republican and Democrat, asked for additional information, and they provided it, and we brought it forward. What was interesting is the other side of the aisle actually mentioned Trump a whole lot more than they ever mentioned Biden. And it's happening over here, too. So I think it's kind of consistent both in the Ways and Means Committee and in the Oversight Committee. But Ms. Connor, my question is yesterday, the Ways and Means Committee voted to release additional information provided, like I said, by Gary Shapley and Mr. Ziegler. One of the documents shows that Assistant U.S. Attorney Leslie Wolf ordered investigators not to pursue leads into possible campaign finance violations. We know that over $2 million of Hunter Biden's tax liabilities were paid off by a big Democrat Party donor and Hollywood lawyer who's named Kevin Morris. James Biden, the president's brother, told investigators he did not know how Hunter Biden even knew this individual, but was later asked to thank him for the payment, quote, on behalf of the family. The Biden family. The family. So how would such payments that essentially pushed under the rug the president's son's tax problems, at least for 1 year, be considered a campaign finance violation on part of the Biden campaign?
Thank you for the question. I have no idea. I thought you were going to ask me, why would Leslie Wolf say, don't look into that? And I think the answer to that probably is that if it's a campaign contribution, then it implicates political person number one. And that apparently is a big barrier that had been created throughout this entire investigation. And as far as it being a campaign contribution, that $2 million actually was intended to satisfy the liabilities for 2 years of Hunter Biden's late filed and unpaid taxes.
Is it unusual for an assistant prosecutor to say, don't look at this individual, this person's off limits?
As I mentioned in my opening statement, that is how investigations develop. The agents follow the leads wherever they take them. And in this case, a legitimate investigation was being done of money that was being paid, and for the assistant U.S. attorney who is orchestrating the investigation to say, don't look at that anymore, I think the reason is related to another instruction of hers that she didn't want to get public integrity involved. And that tells us that she was looking beyond Hunter Biden and into a person whose activities would be subject to public integrity at DOJ.
One thing that I want to ask, since you worked tax division for DOJ, if Kevin Morris gave a gift of $2 million to help pay off Hunter Biden's debts, who has to report that on their taxes? Does Mr. Morris have to report it, or does Hunter Biden?
Well, as I understand it, the parties are claiming that it's a loan and that Hunter Biden will pay it back between 2025 and 2027.
Would that have to be reported on any tax records?
If it's a loan, no, but I haven't seen any of the documentation of that loan. And that is one, I'm sure Mr. Dubinsky can tell you that calling something a loan is one way to claim that it's not taxable income.
So one quick question. You know, we uncovered yesterday that the Biden family and associates received over $20 million from 23 different countries that they had business ties to or communications with. And they also had over 20 shell LLCs where they would transfer money in and out. If you were still sitting in your office in DOJ's tax division, would this web of entities and activities concern you?
I would make sure that my prosecutors were concerned about it.
Thank you.
Thank you. Chair now recognizes Ms. Norton from the District of Columbia.
Thank you, Mr. Chairman. Professor Gerhardt, pleased to have you with us today. In your testimony, you referenced Alexander Hamilton's warning about the dangers of trivializing impeachment through petty partisanship. Let me ask you, Mr. Gerhardt, do you think that initiating an impeachment inquiry against President Biden without any evidence of wrongdoing by the president meets any basic standard of proof?
Not credible proof at all, in my opinion. And in fact, I think one thing to keep in mind about a hearing like this or any kind of anything that calls itself an impeachment inquiry is the critical importance of building public trust. And that gets built in part on the basis of credible evidence.
Well, Professor Gerhardt, what is the risk to our Constitution and even for the rule of law if impeachments are initiated without any evidence of wrongdoing by a president?
They trivialize impeachment, they trivialize the Constitution, and they ride roughshod over the rule of law. Nothing good comes from abusing a power, whether it's done by a president or by Congress.
Professor Gerhardt, do you believe that initiating an impeachment inquiry without any evidence of wrongdoing by a president is consistent with the rule, with the view that impeachment is a grave and solemn duty?
Impeachment is a grave and solemn duty, all the more reason why all evidence, for example, relating to Burisma, ought to be heard and considered. That would actually add credibility to what the committee is doing.
I would be remiss if I did not add that it is incredible that we are holding this sham hearing 2 days before the government will shut down. Instead of this hearing, we could be discussing how to fund the government, or we could discuss my bill to exempt from federal government shutdowns the federal and independent agencies that are exclusively or primarily federally funded but have jurisdiction over local D.C. civil and criminal justice matters. Or we could be discussing how we are going to provide back pay to federal contract workers if Republicans unfortunately do push us into a shutdown. Instead, we are holding this sham hearing. I yield the remainder of my time to Mr. Raskin.
Well, thank you kindly, Ms. Norton, for that. Mr. Comer referred to a 2019 wire to Hunter Biden while President Biden was not in office. He was a private citizen, so of course was Hunter Biden. Hunter Biden has never held public office. Mr. Smith referenced a DOJ email from 2020 during the Trump administration. So, Professor Gerhardt, I mean, what do you make of the idea of impeaching a president while he's in office for something that his son did or may have received when the president wasn't in office?
It's not consistent with the American legal system. Just imagine if the names are switched. Just imagine if this was Jared Kushner, or one of President Trump's sons.
Mr. Smith talked about $20 million that he thought Hunter Biden had received and put in the names of different family members. I think the Washington Post has debunked that as recently as this weekend, saying it was like 8 or 9 million. But let's say it were 20 million. That's 1% of the $2 billion that was brought back by Jared Kushner from Saudi Arabia to a company that Jared Kushner created the day after the Trump administration ended. But assuming there were no other evidence, would it be fair to attribute that $2 billion that Jared Kushner pocketed with the $25 million management fee every year that Jared Kushner pocketed? Would it be fair to attribute all of that to Donald Trump because it's his son-in-law?
No, not without any evidence actually showing the president knew it.
Yeah. So,
or approved it.
Because the principle of American law is that people are responsible for their own conduct and not the conduct of their adult children. Is that right?
That's correct.
Thank you, and to the gentlelady for yielding, and I yield back.
Chair now recognizes the chairman of the House Judiciary Committee, Mr. Jordan from Ohio.
Thank you. Professor Gerhardt, it wasn't just a speech. He leveraged $1 billion of American tax money, and he did so at a time when our government was supportive of the prosecutor. Here's what our government said. The Assistant Secretary of State, we have been impressed with the ambitious reform and anti-corruption agenda of your government, written to the Prosecutor General, who Joe Biden leverages our money to get fired. The United States fully supports your efforts to fight corruption, she further wrote. The Interagency Policy Committee said this on October 1st, 2015. The IPC recommends moving forward with a third loan guarantee to Ukraine in the near term. And even after Joe Biden gives the speech on December 9th, The European Commission said, their report said the anti-corruption benchmark is deemed to have been achieved for Ukraine. But the most telling evidence is what his business partner said. Devin Archer, when we deposed him under oath just 2 months ago, said this. Here's the question. The request was help from the United States government to deal with the pressure they were under from their prosecutor. You know what Mr. Archer's response was? That's correct. Next question. What did Hunter Biden do after he was given that request? He called his dad. That's what we're investigating. That's one of the 3 things Professor Turley talked about, the influence peddling scheme. I want to go to those 3 things, Professor Turley. False statements, influence peddling scheme, and Joe Biden might have benefited. Let's do the third one first. Is a benefit to your family, can a benefit to your family be a benefit to you?
It is. There's been repeated statements that you need to show that President Biden accepted direct money in order for this to constitute a benefit, even under criminal cases that deal with bribery, extortion, the Hobbs Act. The courts actually have rejected that. They've said that money going to family members is in fact a benefit, and I don't really see any legal basis for that. Obviously, the strongest case is if you have a direct payment, but this idea that you can have millions going to a politician's family and that's not a benefit, I think is pretty fallacious.
Yeah, how about the false claims thing? In your written testimony, you said to the extent that the president has used the White House, I think this is a little broader. To the extent the president used the White House staff to maintain false claims or resist disclosures, it can fit into the type of Nixonian abuse of power model. We know all kinds of false statements have been made by the White House. Joe Biden's made them. He said it was a lousy question when they asked him, have you ever been involved, talked to any one of your son's business partners? We know that was false. Ron Klain said, the president's confident his son didn't break the law. Press Secretary Jen Psaki said never spoke to his son about his overseas business dealings. What do you think about all those false statements from the White House in this abuse of power issue?
Well, the involvement of White House staff and executive branch staff has been really one of the tripwires that we saw in Nixon, to some extent even in Clinton. The degree to which you enlist support for a false narrative or to obstruct Congress can go into things like abuse of power. One of the things that I suggested is that if you look at past impeachment inquiries, and once again, this is an inquiry to find evidence, you're not voting on articles of impeachment, those allegations tend to develop last, and you look at what you have found.
Yeah. How about the Attorney General? I'm concerned about statements he made. March 1st, 2023, in front of the Senate, he was asked a question about Mr. Weiss's investigation. He said this in response to Senator Grassley. Mr. Weiss has full authority to bring cases in other jurisdictions if he feels it's necessary. Last week, the Attorney General told us that Weiss had the authority because I promised him he would have the authority if he asked it. That seems to me to be something different. He said to the Senate, he's got full authority, no problem. Last week he told the House Judiciary Committee he had authority because I promised if he come talk to me, I would give him the authority that I already told the Senate he had. Do you see a concern there with false statements coming from the Biden Justice Department?
Well, there is a concern. You don't have to prejudge the evidence to say that obviously this is part of the inquiry. And what I don't understand is the opposition to the inquiry itself. It seems to me the test is, would the alleged conduct, if proven, establish impeachable offenses? And is there a credible basis for those allegations? I think the answer is clearly yes, that there is a basis to look at the president's conduct without prejudging whether that qualifies at the beginning of that inquiry as an article of impeachment.
And let's be clear, you don't need a full vote of the House to proceed in an impeachment inquiry phase of our constitutional duty to do oversight. In fact, the Democrats did it. 4 years ago, I was in an impeachment deposition run by Adam Schiff in the bunker in the basement of the Capitol, and I went to the floor. So I'm in an impeachment deposition, and I went to the floor to vote on opening an impeachment inquiry. They did the same darn thing because you have that authority as a Congress when the Speaker of the House makes that designation.
The Speaker, Nancy Pelosi, did in fact initiate the impeachment. In some cases, then you have a later vote. I've said in my testimony, I consider that the best practice to have a vote of the House. But the court that was referenced earlier looked at this and said that the Constitution does not require resolution. Actually said if you look at all the impeachments, often there wasn't a resolution. That doesn't mean it's not a good practice, but the Constitution itself does not require such a resolution.
Thank Thank you. Gentlemen, time's expired. Chair now recognizes Mr. Lynch from Massachusetts for 5 minutes.
Thank you, Mr. Chairman. First of all, I do want to agree with the chairman that the witnesses we have here today do bring an awful lot of experience and expertise to the issue. But what they don't bring is facts, right? They don't bring evidence. None of you are able to really elucidate or illustrate actions by the president with respect to this inquiry. Ms. O'Connor, I do want to ask one clarification. You mentioned in your oral testimony that you had written a commentary entitled, "You'd Go to Prison for What Biden Did." That was, you'd go to prison for what Hunter Biden did. Isn't that?
That's exactly right. I was cutting down words to stay within my 5 minutes.
But you realize, yeah.